Charlie. Good morning. Welcome to oral argument session of the 5th District Court of Appeal. As the Marshal Charlie indicated, I am Judge Lambert. I'll preside this morning over the one case that we have. The panel seated to my right is Judge John Harris, and seated to my left is Judge Meredith Sasso. Like I said, we do have one case, and let me say initially I appreciate everybody's willingness to reschedule the oral argument from tomorrow till today. It was set for a law day case, but as I pondered it more, it seemed like this probably wasn't going to be a good case to discuss with high school or junior high school students present, because then their parents might say something to the school board, and then we'd all be in a discussion about things. So we decided that we would just have this in a regular court session here, and anybody who wants to attend can attend, and that's fine. Okay, just a couple things. There's 20 minutes to a side. For the appellant, I will keep 5 minutes for rebuttal unless you tell me you want to have something else than 5 minutes, and I'll adjust the clock accordingly. If there are any cell phones or any other electronic devices on, please either turn them off or mute them so that they don't go off during the course of the oral argument and distract either you or your opposing counsel or even us. So, all right, case number is, with that all said, we'll start. Case number is 21-1542, James Enriquez versus Ashley Velasquez. I apologize if I'm mispronouncing. Correct me if I've mispronounced anything, please. So, counsel, whichever counsel's here, ready to go?
May it please the court.
Yes, ma'am.
Good morning. It's a pleasure and honor to be here in front of you all. My name is Erin Newell, and along with Shannon Macklin and Florida Appeals, we represent the appellant, Mr. James Enriquez. We would like to reserve the 5 minutes for rebuttal. Thank you, Judge Lambert. Mr. Enriquez is present here at oral argument this morning along with his mother. Mr. Enriquez and the appellee, Ms. Velasquez, were equally parenting and time sharing with their daughter for 2 years when the final judgment terminating his parental rights was rendered. The child was 6 years old. Temporary time sharing was entered upon the parties' stipulation to paternity. James Enriquez is the biological father of this child.
And Ms. Velasquez, the stipulation of paternity. When I look at the petition is styled as an action to determine paternity. There is a paragraph 9 paternity facts, which is admitted, but not a legal stipulation. And so I guess my question is, was there an expectation based on the way these pleadings were made that there would be a determination of paternity in this case?
The formation of the pleadings, I believe, are made to comply with the law. There was an allegation of paternity, and there was an acceptance of that allegation by the answering party. So I believe that the expectation between the parties was always, and has always been, that Mr. Enriquez is the biological father of this child. And the trial court even notes in its final judgment that the parties never question Mr. Enriquez's parental rights. In other words,
so paternity was before the trial court.
That is the nature.
A determination of paternity was before the trial court.
Correct, and that's the subject matter jurisdiction of the court, Your Honor. So
the threshold matter that the trial court needed to determine was whether or not your client was the father of this child according to the law.
Correct, Your Honor. That was the subject matter, and the issue truly was one of standing, whether Mr. Enriquez, there was some legal reason that he was not the father. But the jurisdiction in Chapter 742...
That's not quite how Florida law is set up, though. It's not a presumption that he is a father until proven not to be the father in this situation when the child is born outside of a marriage. There's several procedures, including 742.10, for establishing paternity for children born out of wedlock, correct?
That is correct, Your Honor. And all of the cases that are discussing 742.14, which is the statutory termination of parental rights in cases where there is a donor in assistive reproductive technology, all of those cases involve an affirmative defense that is raised by the other party to standing based on that statutory waiver. So the cases, including the Florida Supreme Court case in 2013, that involved the other party that had given birth challenging the standing of the biological parent on the basis of that statute as an affirmative defense. There was no affirmative defense, as Your Honor mentioned. The pleadings actually admit it, and the stipulation does come in during the hearing on temporary timesharing. That's where the stipulation comes in, and that order is in the record on page 50.
So that would be a stipulation as to the facts, but a trial court is not bound by any stipulations as to law, correct? Would you agree with that?
I do agree with that, Your Honor. I was an interlocutory, essentially ruling that the trial court decided to revisit in the final hearing. However, the way in which it was revisited was a complete denial of the father's procedural due process rights, because there was absolutely no notice. There was no notice in the form of pleadings. There was no notice.
That's what I'm wondering. If the pleading put paternity at issue, if the trial court was going to have to make a legal determination, it was not bound by any stipulation as to the law, how could there be no notice when that was what the petition was titled, when it was clear from the petition that paternity was an issue? There might be, cases that apply or statutes to apply that issue that the parties had not anticipated or thought of, but how does that equate to no notice of the issue of paternity?
It equates to no notice because it is incumbent upon the other party, the mother, to raise a defense to his standing as a parent. He had been exercising those parental rights for 2 years. 2 years. We're not talking about 2 months. We're talking about 2 years of dedicated support.
So your argument would be that there would need to be an affirmative defense interposed in order.
And every case, Your Honor, that deals with this question involves an affirmative defense. Everyone, including the Florida Supreme Court case in 2013.
That's a little different than the issue that was made in the brief, though, right?
I believe it is part of the notice inquiry, Your Honor. I mean, the most traditional way to give notice of a defense is through pleading. Of course, pleadings can be amended. There can be issues that come up at trial that are agreed to by the parties. However, that's not what happened here. The court, at the end of an evidentiary hearing about the best interests of the child under 6113, to determine time sharing, and the parties were not far apart in this case, and the trial judge notes that in the final judgment. We're talking about whether it's every other weekend or equal. That was the issue. That was what was before the court. And then at the end of this entire hearing, the court says, you know what? There is this statute that I'm curious about. So that is not adequate notice. Procedural due process requires more, absolutely requires more. And the other aspect...
Let's assume we agree with that for the moment here. The facts really aren't in dispute. I mean, it seems to me at the end of the day, setting aside the issue of the constitutionality of the statute that's been raised, that it comes down to a question of law here as to the applicability of these reproductive statutes, or whatever term you want to use, to the facts of this case. So taking your first argument about the lack of due process, if we said, okay, you're right, lack of due process, we send it back to the trial court to do what? I mean, I know you've keeping in theme with the motion for your due process issue, I mean, you raised all these things in the motion for rehearing, which the judge denied less than 4 hours later, well, not in the middle of the night, I guess, late in the evening of your motion being filed. So that seems to, you didn't get to even talk about it. Not that you're entitled to talk a hearing on a motion for rehearing, but
correct, Your Honor.
But I mean, getting back to what my initial premise. So what is accomplished by going back and re-arguing the matter? I mean, there's no other facts that you would put in. The judge already found that he was, he's involved. He was called dad. He's been seeing the child for 2 years before this trial, and
absolutely
so
all the facts.
What would you tell the judge if we said, okay, we're just going to reverse on issue 1 and have a nice good luck and see what happens?
If there was a reversal just on issue 1, which is a procedural due process, it should be a very narrow remand. The issues have already been presented to the court. What was actually at issue should be adjudicated. The court has already made rulings that indicate, the judge can make a ruling on 6113 about time sharing, about child support,
but
about
isn't
school
this judge
designation.
it's going to come back and the judge will say, okay, 50CA sent it back for me to give due process. Okay, we are now going to have a scheduled hearing for 4 hours to talk about the
The statute.
applicability of 742.14 to otherwise undisputed facts.
That would be an egregious waste of time in this case. This child is 6, and it's been a year since she's seen
Well,
her father.
I understand, I get all that part, but I mean, I'm just, when you're saying you want us to reverse because it's due process.
Well-
So, I mean, and I get the angst that this was faced at the end of the trial, that the judge says, oh, by the way, what about this? Okay, but, okay, now it's there now, and you've moved to rehear it.
Yes.
It's been briefed. If we send it back on that issue, because we decide, we don't have to decide every issue in a case, what happens?
I believe that the court can narrowly frame the mandate. However, really what should happen, because this issue has been fully briefed before this court, there's nothing further this court needs to see in the record to decide the issue.
So in other words, you've raised the due process argument, but really,
this court...
that's in the rearview mirror.
I agree with you wholeheartedly. Really, this court has
You have to,
everything
you don't
before
want
it.
to, but I mean,
Absolutely.
yeah.
This is the Assisted Reproductive Technology Statute. The Florida Supreme Court has dubbed it the Florida Assisted Reproductive Technology Statute because it has to be read in peri materia. Subsection 742.13 and 742.14 are read together.
So your view, though, is that your opponent is just reading the one statute?
That's absolutely correct.
742.14.
And as the trial court was, opposing counsel is being led by some second DCA case law that is really been questioned. The validity of La Marita has been expressly questioned by the Florida Supreme Court in the 2013 case, DMT, and also AAB, which also came out in 2013, several months before the Florida Supreme Court case, is completely questionable. Now that there's guidance from the Florida Supreme Court that this court is essentially constrained to construe this statute in peri materia, which it should have done anyway. I mean, as a term of statutory
Can I jump ahead to your
construction.
third argument for a second about the constitution? Oh, I guess that's your third and fourth, perhaps. But the constitutionality issue you raised in the alternative, do we actually have, are we even able to do that here in the sense that you have to file the 1.071, or I guess it's 12.071 notice of constitutional question, and your colleague or your co-trial counsel, I think, filed that notice 3 or 4 days after the motion for rehearing was denied. So in essence, wasn't the case over with the denial of the rehearing at that point? And are we precluded under Lee? What's that? I can't remember. There's a Florida Supreme Court case. I'll look at the site that basically says, we can't address constitutionality questions that are raised after the trial court case is over. And I understand your timing because of what the trial judge did, but
Correct.
But we're looking at what authority do we have to do that in light of the Supreme Court directive?
As far as the timing of when the notice of constitutional question was filed, I don't recall precisely how to answer that question, Judge Lambert. However, I can say that on appeal, we did follow the appellate rule that governs this issue, which is Rule 9.425. And in that rule, it directs the party that files a brief questioning the constitutionality of a statute, a state statute, to give notice to the Attorney General at the time the document is filed, which we did. We gave notice of the notice of appeal, which had the order attached to it, of course, and then the brief was also served to the Attorney General. So insofar as this court is authorized to consider the constitutionality, if it should treat the father as a donor under the statute and find it necessary to consider whether it's constitutional as applied, the appellant did comply with the appellate rule regarding this issue and believe that the court does have the ability to consider it. If the court should treat Mr. Enriquez as a donor, there absolutely has been a transformation of his inchoate right as a biological father to a substantial constitutional protection. It is a fundamental right in this case. There is no question. The heart and soul of this matter shows his commitment to his child in every way, shape, and form, and this is unconstitutional as applied. For those reasons, the court should reverse the order and remand for the court to adjudicate the issues that are presented before it properly. Thank you.
All right, thank you. Hang on.
Oh, I don't need 25
You
minutes.
get more time than I thought. All right. Okay.
Good morning. May it please the court. I am Jamie Bellotti Moses, and along with my co-counsel Chad Barr, we represent the appellee Ashley Velasquez. She apologizes for not being here today, but for medical reasons she could not travel. We are sensitive to the delicate issues involved in this case, and we are not unmindful of what the final judgment resulted in. However, we are asking that this court affirm the final judgment because appellant does not challenge or suggest that the statute is ambiguous. It's agreed that the statute is unambiguous. An appellant does not challenge or suggest that the facts were in dispute. So the real issue for this court was whether the trial court applied an unambiguous statute to undisputed facts, and we would submit the trial court did. With respect to the due process and the notice issue, Judge Lambert touched upon what would have been presented to the trial court if the appellant was under the impression that his parental rights were being questioned. The final judgment is very clear that, and we don't have a transcript of the proceedings, and we are not arguing you should affirm simply because there's not a transcript. We have promised appellant we would not make that argument, and we are not making that argument. However, the absence of a transcript should not be used to suggest that these issues weren't presented to the trial court. It is clear in the final judgment that Mr. Enriquez put on testimony. It was only the mother and Mr. Enriquez who testified at the hearing about his relationship with the child, the extent to which he was involved, the extent to which he loves this child was before the court in reaching its decision.
Well,
yes,
I mean, but for the trial judge interjecting at the last second, the judge would have entered a final judgment and he would have had time sharing. I mean, that it is what it is.
Yes, sir.
We can debate about that, I guess, but we don't really need to. I mean, but you're saying 742.14 is unambiguous. So if we look at it that way, tell me why somebody, since it doesn't talk about any kind of reproductive technology, so why would not a man and a woman who had a one-night stand, who met each other that first day and decided to have sex for whatever reason, and then she became pregnant and had a baby, why would he be a sperm donor?
No.
Why not?
I don't think any couple in that situation is contemplating the donation of their reproductive. I mean,
well, you're reading stuff into. I mean, you know, you want to read the literal language of the statute. I mean, he's donated sperm, and he's relinquished his rights.
But the facts of this case are actually he donated his sperm and it was artificially inseminated into my client to produce a baby. A one-night stand is a different story. I don't think there's any discussion before a one-night stand. I don't know, but I would assume there's no discussion regarding this is mine, this is yours, and if it happens, I'm really glad we didn't do this in front of the students. But if this happens, you know, it's not a donation, it is a donation. The facts of this case are that
okay,
it was...
let's take it away from that. All right, you don't like that one. I'll try this one.
It's not that I don't like it,
sir. So they know each other. They're sober, and they decide that or the lady decides that she would like to have a baby with this guy's sperm because, I don't know, he's looked like it'd be a good child produced from that coupling. And so they do it I think it was a Barnhill case, they do it the old-fashioned way, whatever that means, I guess. I think we know what it means. But in any event, so he donates the sperm in that case because she wants to have a baby. This is not just a random coupling. I want to have a baby. Please give me your sperm through sex, and I'm going to have a baby. But we're not going to be married. We're not going to be romantic, other than whatever the romance is for the event. And if she changed her mind and said, you know, by the way, now that I've had a baby and I'm raising this kid, this guy's making $1 million now, I think he needs to provide some support. He is the father. Why does the statute? Wouldn't the statute apply in that scenario, that the man would be able to walk away and say,
I think, Your Honor, the law is pretty clear that there are no parental rights or obligations just at that moment of conception. I think the law is pretty clear on that, and it's the effort to be a parent which transforms it into constitutional parental rights. In your scenario, if he was just gone and she suddenly goes after him to be the father, I think testimony would be taken and presented as to whether there was this discussion. He would have a good argument that she told me she wanted to have a baby, that she didn't want me to be a part of its life. I thought I was just giving it to her. There's an argument in that situation. There are many hypotheticals. I'm not suggesting that I agree with this statute or that I even like this statute. All I am suggesting is that the trial court applied the statute to the undisputed facts in this case, which it was an artificial insemination with his sperm. They weren't a couple. They weren't a commissioning couple. There wasn't a pre-planned adoption agreement. This falls within that statute, and the trial court properly determined it didn't have jurisdiction to adjudicate parental rights.
It had jurisdiction. I mean, this is not a subject matter jurisdiction. This is a lack of standing. This is a person who's not legally the father. In other words, if the man next door filed a paternity action saying, I want to be declared the father of this child, and he had nothing to do with it, the court has jurisdiction to rule that. The man just has no standing to bring it because...
Well, okay, if we're parsing words, I think the court...
I know. I think subject matter jurisdiction is not a parsing of words.
Well, I think the court determined it did not have the ability to adjudicate the rights that the father was asking for.
Denied his petition. It's clearly said in the judgment it had subject matter jurisdiction.
Over the action, yes, it did.
Right.
This was an action over a child.
The guy lost his case.
He did.
That doesn't mean there was a lack of subject matter jurisdiction. It means he just didn't prove his case because he couldn't, as a matter of law, prove he was the father. Legally.
Correct.
Okay.
Okay.
Well, so telling a panel of appellate judges that there's lack of subject matter jurisdiction causes us to go down a rat hole here of
I understand that. I think it's because, there are cases that are brought that the court determines, wait a minute, although I have general jurisdiction over this issue when it's originally brought to me, this is a family law matter, it was brought in family law court, it was a petition for paternity, and then the court says, wait a minute, I can't do this. I can't do this. This man doesn't have parental rights based upon how this child was conceived.
I can't grant you relief, so I deny.
I can't grant you relief. And that's what the judge just did in this case. He said, I can't give you what you're asking for because of 742.14.
So what's your response to the argument on the statutory interpretation that because Section 14 is lumped in with 11 to 17, which all refers to some sort of formal in vitro fertilization, gestational surrogacy, laboratory setting, artificial insemination, that this is, that Section 14 refers only to that laboratory setting sort of situation?
Well, it actually doesn't, because Section 14 also refers to a pre-planned adoption agreement under the adoption statute, and they don't talk about assisted reproductive technology in a clinical setting. They don't use the same definition. They use other definitions, but they don't use that one. The assisted reproductive technology in a clinical setting is in reference to defining what constitutes a commissioning couple. It is a definition within a definition, but I do not believe it becomes a limitation on the application of subsection 14. If the legislature wanted this to apply to only assisted reproductive technology in a clinical setting, that's all they had to say. And the legislature has not amended this statute. AAB came out in 2013. AAB came out before DMT did. So the suggestion, it was mentioned in the brief that the second district did not have the benefit of DMT at the time it wrote AAB. Well, the Supreme Court did not criticize AAB when it wrote DMT. And I tried to look at the briefs to see if it was brought to the court's attention at any point in time or whether there was a notice of supplemental authority. But the Supreme Court did not criticize AAB and the context of a child being born outside of an assistive reproductive technology in a clinical setting. Again, the legislature went so far as to define assistive reproductive technology in a clinical setting in the definition section for a commissioning couple, but did not do so in its implementation statute.
Why couldn't they be a commissioning couple? They're the intended mother and father of the child who will be conceived by means of, I guess you're saying this is assisted reproductive technology because you think the statute applies to what happened here.
Well, no, I don't think I've made that leap. I think I believe that this was artificial insemination. I do believe it's assistive reproductive technology to the extent it was not done the traditional way, but I believe appellant's argument is, and I don't want to misconstrue it or make it for them, but they add the in a clinical setting. This was not clinical. This was done at home. And so...
Let me ask you some questions about that on this unambiguous statute. If Mr. Enriquez is not a donor under the statute, then this case is over, right?
Yes.
We go back in the trial court, then resolves what Mr. Enriquez thought the trial court was going to resolve.
Yes, sir.
And you're saying that the term is unambiguous, in this case, the term donor, which in other legal contexts could mean someone who makes a charitable gift or funds a grant or funds a trust. I mean, those are all donors, right?
A donor is someone who gives.
Okay, and in a medical setting, doesn't this term almost universally contemplate a clinical setting or laboratory involvement?
I can't speak to that. I mean,
Donor, blood donor, plasma donor, organ donor.
In those instances,
Even
yes.
in other reproductive cases on the statute, egg donor, pre-embryo donor. Why are we treating this different? You can't be a donor in any of those circumstances without some degree of medical assistance. Why are we going to treat one who provides sperm as a donor simply because apparently this goal can be achieved at home?
Well, that is one reason why. If the legislature intended to restrict this to a clinical setting, then they could have very easily said that. The legislature is presumed to know that you can donate your sperm in a non-clinical setting and didn't go out of its way to restrict it. They restricted it in the definition of a commissioning couple, but they don't restrict it in the statute as a whole.
Well, let me ask, when the Supreme Court says it is clear that the primary purpose behind the legislature's enactment of the Assisted Reproductive Technology Statute was to ensure that couples taking advantage of medical advances in reproductive science to conceive a child are protected from a claim to parental rights by a third-party provider of the genetic material used for assisted reproductive technology. I think that's kind of what Judge Harris is alluding to, is that there is no third party here. I mean, if the Supreme Court, and it might be a Supreme Court decision that, you know, is in line to be set aside by the new Supreme Court, as has been happening.
Yes.
But we don't get that prerogative now. That's the legislature. They say this is what was the intent of this statute, and I would think you'd have to concede, maybe I'm wrong, that this isn't the third party. You know, this is to prevent some other donor from giving sperm to these two people to facilitate the conception of a child.
Well, my response would be, number one, the case says primary. Number two, it's not in the statute. I mean, this was a court that determined that was the legislature's intent. It doesn't say that in the... How easy would it have been to say a donor of sperm, ova, or egg in an assistive reproductive process in a clinical setting, and then carries on? They don't do that.
Including any setting that's at home.
Well, but the absence of it doesn't suggest that it doesn't include that. I think the absence of the clarifying language suggests that the legislature did not intend to restrict it to that. If they knew to write it in 13, why didn't they write it in 14? I don't think it's this court's role to write that in.
Well, I guess I'm going to have to be convinced why I'm not bound by what the Supreme Court says that the primary purpose of the statute is.
That's primary. It's not the only purpose. And I don't...
Is that your best argument?
Well, no, that's not my best argument.
All right, well, I'll respond. That hasn't convinced me, so go
Okay,
ahead.
okay, yes, Judge Sassen.
Sorry. If we follow the Florida Supreme Court's most recent pronouncement that we follow supremacy of the text in all circumstances, and we look at what the legislature actually enacted rather than what it intended, Why, I guess, is there a textual argument or contextual that because this is grouped in, that this would be limited to those laboratory settings? Or is your argument that based on what the legislature enacted, that it left open to donation in all sorts of settings, including home settings?
Our argument, and it was in our brief, is that the legislature is presumed to know how its statute is being interpreted. There are cases out there interpreting this in the context of a non-clinical setting, and the legislature has not rewritten its statute to limit it to clinical settings. This clinical setting is in the context of a commissioning couple and its definition. A commissioning couple uses assistive reproductive technology resources in their effort to be parents, and that is where the definition comes in. The legislature has not, since 2013 when AAB came out, or Lamaritas, which I don't know the year that is, but the legislature has not amended this to say, wait a minute, we said this only applies when it's a clinical setting and it's assisted reproductive technology. It has not done so. And although the Supreme Court says it's the primary purpose, I understand that that's the primary purpose. That is not the only purpose of this statute.
What's the other purpose? What's the non-primary purpose?
Well, because my client did not intend to raise this child with Mr. Enriquez. She didn't. She wanted to have a child. He agreed to give her his sperm, and she has a child that she is raising as her daughter. She could have married him.
That's not really what she said. She said she intended that he would be involved in the child's life. She just didn't want to co-parent.
Like an uncle. I mean, he could be involved like an uncle. She did not want to be co-parenting with this man.
That doesn't mean she doesn't want him to also be a parent.
She doesn't want to parent with him. I think it was pretty clear she wanted to have a child. He was willing to donate his sperm.
She was consenting to his parental, she was acknowledging paternity. I forget about the, she admitted in her pleadings that, she didn't have any objection to the final judge. There was no, but for the judge opening his mouth at the end, there would have been no objection to the final judgment saying, I declare this man to be the father of the child, from your client. Isn't that fundamentally obvious?
I'm not going to deny that, sir.
So that means that she didn't have any objection to him being the father and having father parental rights with the child, because that's what she agreed that they were going to litigate as to what kind of involvement he was going to have, his parental rights vis-a-vis time sharing, child support. I mean, go ahead. I'm sorry.
Let me ask another question. In D&T, Supreme Court said that the best interests of the child should ultimately determine the roles each parent's going to play. Obviously, at the proceedings below, your client was focused on the best interests, or what she thought were the best interests of her child. Is there anything in her position in this appeal that even remotely takes into consideration what would be in this child's best interest?
Have we taken a position with respect to best interests?
Anything in this appeal, on your client's position?
No. I mean, we're not going to suggest that Mr. Enriquez would harm the child, or we're not going there. That was not an issue that was, because that would not be in the child's best interest if he was not, if he was harmful to her. We're not suggesting anything like that.
Where that's coming from, but what about best interest of having a father figure in her life, having another source of support, having another family, inheritance, whatever? Many reasons why having Mr. Enriquez involved in this child's life could be considered to be in the child's best interest, but that's not your client's position at all anymore, right? There's no focus on what's in the best interest of the child as far as this appeal goes.
We have not discussed that in the appeal, Your Honor.
Is it your position that if this court wrote an opinion affirming that there are no circumstances under which a donor through an at-home method could obtain parental rights?
No, that's not our position, that there's no circumstances whatsoever, no.
And that that donor, like any other unwed father, would just follow the statutory scheme for establishing those rights?
I think.
And if you haven't thought about it, that's fine.
Well, no, it's not that I haven't thought about it, but the case law gets jumbled because much of the focus in DMT was on the egg donor mothers' efforts after the child was born, and there was a lot of focus on that, and that has been used to suggest that efforts after birth mean something, that you can sort of back off from the relinquishment of the parental rights. I'm running out of time. Can I finish the question, Judge Lambert? But the reason why that was such an issue in DMT is because those women were trying to qualify as a commissioning couple and could not under the statute. I don't think that the statute as it's currently worded, you said to fall within the statutory scheme to establish parental rights. I don't think 742.14 defines how a parent could do that. So I just want to make sure that I answer the question appropriately. I mean, I will admit, if we don't like the way the statute is written and all the issues are raised by the amicus, that is something for the legislature, not this court. And so we would ask that you affirm the final judgment of the trial court.
Okay, thank you. All right, counsel, you have 741 in rebuttal.
Where to start? This
Somewhere.
guy in this case, Mr. Enriquez, the father, lost more than just his case. He lost his daughter. That's what happened here. The evidence that was presented, that was alluded to by the opposing party, was about the best interests of the child. That's what was at issue here,
Well,
6113.
this was an action to establish paternity, right? So there were no...
But the issues that were noticed by the former wife in her at page...
Can I ask you, though, on the statutory interpretation issue, what is your response to the argument that the legislature could have added in a laboratory setting? It left it out. That left open the option of donation in all sorts of settings, including at-home do-it-yourself techniques, and that by adding in or limiting that section to in laboratory settings, this court would essentially be adding words to the statute that don't otherwise exist.
I answer that question by directing this court to section 742.131, which is titled, it's a definition of assistive reproductive technology. Read that. It means those procreative procedures which involve the laboratory handling of human eggs or embryos, including one of those instances in vitro fertilization.
That definition, that language,
Yes.
that term of art is not included in 14, though, you would agree?
That is titled definitions. This statute defines...
Definitions of the words used in the statute, which the
Correct.
legislature chose not to use in section 14.
Your Honor, as just a basic principle of statutory construction, statutes that relate to each other cannot be construed in vacuums. Construing section 742.14 in a vacuum to suppose that any donor, as Judge Harris points out, a donor is someone who gives. If we're going to give this broad, uninformed interpretation to that statute, 742.14, what's stopping a mother in Judge Lambert's scenario who just changes her mind from coming to court and saying, you know what, this one night stand, he just kind of gave it to me.
Is that a textual argument or a policy argument, though?
It's a policy argument, but Your Honor, I'm trying to make the point that it does not make sense. Construing the statute 742.14 by itself and giving this broad, expansive definition of any donor makes no sense in the context of Florida's assisted reproductive technology statute. The Florida Supreme Court instructs the courts to construe these statutes together. The Florida Supreme Court refers to this statute as Florida's assisted reproductive technology statute because that's what it is.
Would a donor in an at-home situation be able to avail themselves of the pre-planned adoption?
Your Honor, no. And I would like to point out something to the court about DMT, which is the 2013 Florida Supreme Court case. That case didn't discuss so much whether the mother was a donor because she clearly was under the statute. Her, the biological mother, and the receiving mother went to a lab. They went and did an in vitro fertilization, and in fact, the biological mother in that case signed a statutory waiver. She was informed of what was going on. She signed a statutory waiver. That is in the opinion.
In order to accept that argument, do we need to conclude that 63.213, which is cited in Section 14, also has some sort of limitation to pre-planned adoption agreements for donations that occur in a laboratory setting.
If the court, if I'm understanding Your Honor correctly, I believe you're asking if this court was to find that Mr. Enriquez is not a donor, would that somehow affect other at-home inseminations from being able to do a pre-planned adoption? Is that what Your Honor is asking?
Well, yeah, I'm trying to read 742.14 and peri materia with 63.213.
I don't believe that construing and treating the father of this child as he should be treated, a biological father whose inchoate rights vested, and it was by all means the father of this child, I don't think that would have any effect on other individuals who want to take a step of formally adopting. I don't believe it's necessary under the statutory scheme as it stands now.
Doesn't that weigh in favor, though, of an interpretation that 724.14 is not limited to only donors in a laboratory setting? In other words,
Your
there's all
Honor.
sorts of people there's all sorts of ways the legislature contemplated that people might bear a child outside of a traditional marriage and chose to include that in the section.
No, Your Honor, and I'm going to answer that by looking again at the prior subsection, which is 742.13, the definition of commissioning couple, right? The intended mother and the father who have conceived by the means of assisted reproductive technology. Why would the legislature create this exclusion for commissioning couples who are actually conceiving through the use of assisted reproductive technology if that is not what the statute is intended to
Why
apply
are these
for?
two not a commissioning couple?
They are a commissioning couple in every way, shape, and form.
Are or are not?
Except. So they are, Your Honor. They are a commissioning couple in every way, shape, and form, except they did not use assisted reproductive
But I mean, if you
technology.
argue they're a commissioning couple, then
There's no-
then it would fall within the statute as a commissioning couple, and then
There's no need to exclude Mr. Enriquez from the statute because it doesn't apply to him. That's the point. This is an exclusion for commissioning couples that doesn't apply to him
let me ask,
because
why wouldn't you ask it in the? I mean, you raised the constitutionality of statute in the alternative. I mean, I think the third DCA just had a case they sent back as to address whether a couple were a commissioning couple.
Mm-hmm.
If they were a commissioning couple under the statute, and the trial judge was wrong, and maybe should take evidence about whether they were a commissioning couple or not, then you would fall. Then the exception to the statute, he would be the father. You wouldn't be having this angst right now of hoping that you convince at least two of us that the statute doesn't apply, and the Supreme Court just not to throw it out because of however they view the statute.
I am familiar with the third DCA case that you're alluding to. It's a 2018 case, and in that case, that was about a motion to dismiss
I
based
know
on a
that, but
defense, right?
I mean,
And
yeah.
so the court went a step further and found that the case shouldn't be dismissed because they were probably a commissioning couple, which entailed evidentiary rulings. But the reason I bring that up is because it was an affirmative defense that was raised. So, you know, just the notion, the opposing counsel is having such a hard time fitting in why Mr. Enriquez is not the father, because he is the father. The facts just don't fit the statute. In this case, the opposing counsel's interpretation of the statute violates the canons of statutory construction. It violates the way the Florida Supreme Court says the statutes have to be construed. They have to be construed. 742.13 and 14 together. This is the Assisted Reproductive Technology Statute, and for that reason, it does not apply to the father in this case, Mr. Enriquez. For that reason, the order on appeal should be reversed and remanded so that the trial court can adjudicate the issues that were properly before it.
Okay, all right, counsel, thank you. All right, we will stand adjourned and take the matter under advisement.